Good morning, everyone, and welcome to Compliance Corner with John Hanson. I am, of course, here with my wonderful friend, John. John, how is your morning going so far?
I'm going really good, thanks.
Awesome, awesome. Okay, so today we're going to be talking about practicing the unauthorized practice of law. And I think that's a fascinating topic, so let's jump into it. Are you performing the unauthorized practice of law? Let's start with this one, John, advising your seller about how to fill out the questions on the Form 17.
Yeah, so there's a couple issues I want to go over this morning, and these things jump out at me all the time. And I know that we've been focusing recently on every day on the COVID-19 issues and what we should be doing or shouldn't be doing. But I wanted to just go into this because I get these on a daily basis, and so one of the things here that concerns me is that when the Form 17 comes around, that we are sometimes entering into dangerous waters and advising our clients and so seller where our seller will check or not to check, or telling our seller what applies or doesn't apply in the law of property disclosure. And so first of all, there are very, very few exemptions from from the Form 17. For example, having never seen the house before is not an exemption. So we want to, make sure that our seller is completing it, even if it's saying, I don't know. In fact, if they have to go through the whole thing and check boxes that say, I don't know or not applicable, that's their business. What I don't like to see is just having them draw a line all the way through, straight down through, because that indicates they're not really thinking about them and just drawing a line. And what does that even mean? So our guidance to our sellers should just be that, there really are almost no exemptions, and you can look up in the RCWs or in the law on property disclosure what those few exemptions are,
Mm-hmm.
and then just let them make their disclosures without you advising on each one. And so if they don't know, just have them check don't know.
Very, very good advice. It is every single checkbox gets checked in some way. Every line gets a checkbox. Okay, so let's try this next one. Crossing out critical lines in our lawyer prepared forms.
Yeah. So this one's a pet peeve of mine anyway, because in my conversations with Annie Fitzsimmons of the Legal Hotline, she indicates to me over and over again that we are not to be Xing out, certainly never Xing out, because when you strike a paragraph or strike a line, you don't make an X. You should only use a quick slash, one line, right?
Mm-hmm.
To delete something. But these are documents that have been approved of by lawyers, and so those lawyers approve of them for a reason. For example, paragraph W on page 5 of our purchase contracts, is for the verification period for the buyer to exercise their right to verify the statements that the seller has made. So does it work to a seller's advantage to line that out? In general, probably not. But in the myopic and really minute, small analysis of it, it seems like that it would, because then the buyer couldn't get out. But in the long-term picture, it certainly doesn't, because it takes away the seller's defense later in court, should they be in court against that buyer, to say that they did give the buyer's opportunity to do their due diligence. Instead, they would be in court saying, with the buyer suing and saying, I had my right taken away when they lined out an important part of our contract. And so we want to, honor the work that these lawyers have done to be fair to our buyers and sellers, and not be just lining things out. The most recent one I just saw yesterday was the Form 22 FM, which is the one for this coronavirus issues that do it. And the first of, what is it, 3 paragraphs in it was lined out, and that was the main one that makes that really explained the whole thing, and it was lined out. So why would we even have that form if that was lined out? So we want to be careful not to mess up this really technical work that the lawyers have done to keep these forms enforceable.
Fantastic point on that, John. And I think that's our agents don't realize that the changes that they're making put both clients in jeopardy at times. I mean, obviously, I think people have a really good heart and they're trying to do the best for their clients, but they're not realizing there's a lot more to it than what they are seeing. That's for sure. Okay, so the next one is post-closing problems.
Okay, so this is a big one. This is one of the biggest issues that comes up to me as the designated broker, is when one of our brokers calls me to say we have this issue where the buyer I represented has come back to me, or the seller I represented says the buyer is coming back after them, and the agent, the broker agent, is trying to fix the situation, which of course you're trying to do, because you're great people. You're trying to keep peace. You're trying to do the right thing and not just leave your client hanging out there by themselves. So it's a issue of finesse, where we have to get across to our client that we're not just leaving them hanging out there by themselves. We are with them, and we are going to, do everything within our power to help them. And we are handcuffed a bit by the law, because the law does not allow us to practice law. Our agency relationship has ended. Therefore, we don't even have that small leniency we're sometimes given during a transaction because of our agency relationship. We're not even given that. We really can't be practicing law. We can't be advising our client on what to do or not to do. They should be contacting a lawyer. Now, we can help them facilitate some communication with the other side, but I say facilitate, it means you give them an email address or a phone number, something where they can make contact and work it out themselves. You shouldn't be engaged in trying to negotiate those things, because if it does go to court, then we're kind of thrown into the middle of it, and because we were trying to do some stuff after closing that we shouldn't have been doing, practicing law. So we want to be careful on this. And again, I say it's a finesse item, because you don't want to let them feel like you're done with them. You want to let them know you're there. You're going to get whatever resources you can for them as far as referrals go, but you're not going to give them legal advice on what to do now that we're closed and there's an issue that comes up.
Well, as always, John, thank you so much for pointing out all of these very, very important items. I think as we go through not only all the things we're doing with COVID-19, but just our daily, everyday practice, it's getting back to the things that we know. And so these are obviously things that we always need to keep abreast of. So John, I hope you have a fantastic rest of your day, my friend. It should be a beautiful day. So hopefully you can get out and enjoy a little sunshine today.
All right, thank you.
Bye.